back to the show. This is The Law Show on CL 650.
Breaking the law, breaking the law. Breaking the law, breaking the law.
Hey, and welcome back to The Law Show on CL 650. I'm Zach Spencer, along with Joe Murphy, Q.C., lawyer and partner at Murphy Battista in downtown Vancouver, and Mike Murphy, also from Murphy Battista. So we're talking about how the court system works. The first segment, we touched on Mike and his background, coming into Murphy Battista several years ago. And we also touched on provincial court and small claims. So maybe, Mike, can you tell us the difference between provincial court and the BC Supreme Court?
Yeah, Zach, as I alluded to before, one of the first questions to be asked in terms of which court to proceed with a lawsuit is going to be what you believe the amount of compensation you're seeking. So if that's $25,000 or below, then oftentimes small claims or provincial court is the right venue. If it's going to be more than $25,000, then oftentimes the British Columbia Supreme Court is going to be an advantage. In some cases, you'd have to consider also discoverability. So in Supreme Court, there's a process in exchanging documents and being able to ask questions in advance of the trial. And if that's crucial to the claim that you're advancing, then some additional consideration should be put into whether or not the Supreme Court is the better venue.
Okay, I'm going back to a high school law class. And so discovery is when both parties bring forward their documents and the information they have, which is for civil matters, right? When criminal, you don't, there is no discovery, right? Is that true?
There's sometimes preliminary hearings where the Crown has to present their case and satisfy the judge that there's enough evidence to go through to a trial. The defense at a preliminary hearing can do nothing. They can just sit and watch and listen, or the lawyer can cross-examine some of the prosecution witnesses to sort of test their evidence.
And the reason I bring this up is because I know it's a different jurisdiction. It's Ontario, but the Jian Ghomeshi story, where we had these women coming forward claiming abuse, and then basically the defense blew everything out of the water when it came to these. It seemed like it in the public anyway. They did,
I'd agree.
And it was pointed out in the media that they didn't have to come forward with all of the evidence that they had on the defense side, where Crown Counsel does, right? In the preliminary hearing.
The criminal system is set up, Zach, to incorporate enough safeguards to prevent a single innocent person from being convicted. Mm-hmm. So the rules are there to prevent an unjust conviction, and those rules result in some people who are guilty being found not guilty or acquitted. The Crown has an obligation to disclose to the defense all the information, all the documents they have that are relevant or may be relevant. But the defense has no such obligation, so they can just sit in the weeds. And in the Ghomeshi case, it's an excellent example because each of the three complainants was called by the prosecution. They got on the stand. They explained what happened and their reaction. And it was only in cross-examination that these women, one of them who apparently said, I was so afraid of him after this assault by him that I couldn't even watch him on TV. And in fact, they had emails from her to Ghomeshi after this alleged assault that essentially said, I really want to see you.
And sent pictures and things, too.
Yeah, so totally discredited their evidence. And the other thing it showed with at least one of the three complainants is that they actively tried to hide that, including their evidence at trial.
They had sort of communicated with each other, right?
They hired the same publicist. So it went crazy. At the end of that trial, and all I knew is what I read in the paper, I thought the prosecutor would say to the judge, you should acquit because the evidence here it can't be sufficient to convict this man. You should just say he's acquitted, which means he's found not guilty. The prosecutor didn't do that. He ran through it, probably because the backlash would be too great if he conceded it.
Yeah.
But the judge had little or no problem discrediting these three complainants totally. In fact, he found not only that they were unreliable, but in some cases that they'd actively hidden the truth. So it was an obvious result. I have a copy of the judgment. I read it because I found the case so interesting. And reading
quite
the
scathing,
evidence,
wasn't it?
Oh yeah, reading the evidence of what these women said when they were called by the prosecutor, and then how much it changed during cross-examination was just amazing. And I felt sorry for the prosecutor because he would have not known that. And the prosecutor, relies mostly on the police to do the investigation and feed him all the information. The prosecutor had apparently said to these women, "Did you have any contact with him afterwards?" They said no. But it was a total ambush for the prosecutor to have the star witness, the first one on the stand who implodes, and then the second one implodes. And I believe it was the third one that said to the prosecutor, either the night before or the morning of her evidence, "There's something I've got to tell you." And she was the one who disclosed it, but the argument Gomeshi made that the judge accepted is she only did that because she knew she was going to be caught.
In the aftermath of that, there was some discussion around the prosecutors. Should they do more digging? And the prosecutors basically said, we did our job. We were given the evidence and we went to court. Now, on the defense side, you do loads of digging. You ask all the pertinent questions. Is there anything you're not telling me? Is there something I should know? Is that true? The prosecutor basically just goes to court with what they're given?
The prosecution should do the full investigation. There should be no surprises at trial. And when I say the prosecution, I mean the prosecutors. They may have investigators that work for them and the police. That should be a team that uncovers all the evidence before trial, because they should have all the evidence before someone's charged with a criminal offense, especially a serious criminal offense. In this case, it's hard to understand exactly who dropped the ball, or it may be that these witnesses actively hid things and were simply believed, but it was a disaster for the prosecutor at trial.
So that's Ontario. Is it different in British Columbia at all?
No. And the Ivan Henry case that just came down with an $8 million award to a fellow who was falsely accused.
Can you give us a backstory on that?
That was a fellow who was accused as being a serial rapist. The prosecutor actively hid from the defense a whole bunch of evidence, which was indicating that he probably wasn't guilty. They had a photo lineup. You know, we all see that on TV, 6 guys standing against a wall and they all look different. This was a photo lineup with Ivan Henry in a headlock being held by a policeman. So
how is that possible?
I know, unbelievable. Henry had some mental problems and I believe fired his lawyer either just before or during the trial. So he did the trial on his own. And I just assume that the judge, who's no longer alive, quickly gained the impression that this guy was guilty. So the trial resulted in a guilty verdict. Henry, on his own, tried to do a variety of appeals, and it was only years later, 20 years later, that someone took on the case, looked at it, and realized how much the prosecution had hid from Henry. So that was the basis that the prosecution had actively hid it. The lawsuit was against the provincial government, against the federal government, and against the prosecutor who, as I say, had died. And he worked for the government. He was a government prosecutor. All cases but one, all parties but one defendant settled, and the judgment that came out recently awarded $8 million for 17 years in jail. And if you're in jail as someone who's harmed or killed a child or a sex offender, you're really the scum of the earth in a jail.
So, Mike, in British Columbia, we have the Supreme Court. So this handles criminal cases like this?
The more serious criminal cases.
And it also handles civil cases, which is what we're talking about, bringing forth a suit over $25,000.
That's correct.
So these judges are dealing with serious murder trials, for example, the Air India trial, and somebody suing somebody, right?
Yes. In many cases, the judges have a very difficult job. They sit in a courtroom and they have to hear the evidence for the first time. They don't have the benefit of hearing it 2 or 3 times and talking to people independently. They hear it. They need to write a long judgment, oftentimes 50 or 150 pages, outlining not only the evidence but their conclusions and how they reach those conclusions. So they certainly have a difficult job, but I think they do it well.
Why are judges? Why are they so long at the end when they have to write 100 pages on this stuff?
Because it's complicated and because they're busy doing a whole bunch of other things. But I would think that the longer a judge waits to release their written judgment, the more difficult it's got to be because your memory of what happened in the trial is fading. A lot of jurisdictions, Alberta encourages judges, encourage with a capital E, to get the judgments done within a few months. It's better for everyone. There have been cases in the past in the federal court. There was one federal court judge whose average reserve was over 5 years. And yet parties actually die before they got the judgment. Well, that doesn't serve justice for anyone.
Now, is there a time limit on
There's no time limit, and each judge has a fair amount of independence. But it must be so much more difficult the longer you wait to finalize the judgment. Like I said,
they're just like anybody else. Some people like to procrastinate, put things off, right?
Yeah.
Well, we've talked about the provincial court dealing especially with bringing claims under $25,000, small claims lawsuits, and British Columbia Supreme Court. We talked about criminal law and civil law, and when we come back, we'll get into the British Columbia Court of Appeal on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.